the first to know Nsem-Pii TV.
Court a call a setna last time. State prosecutor Yamami Yvonne Atakra Obobisa a ono a director of public prosecution na otutu yura kof Richard Japa ano ewabra ono ebabejina adaka mu ene court asan akwa setna senior court no etu ede share da se ene ena yebesan atwa asem ne so no meno e kasa de Godfred Jeboa dame ena take place a ono aron mpaboa ede ama deputy attorney general yewra Alfred Tua Yeboa a meno kasa de ono ena etoto papai ano na eno ena papai ede etu dwa se ewiase onipa bi ase yebu nkompo kohwe wachi aya na o track record ehu nya papa enti ene ewo se yetimi kom the main reason why ntia Greater Japa ye sake no ede ni free military nim ede abone ena oye anya baako anya mienu anya miensa anya nine na dɔɔso enti ono nko abone be nko ena oye a ompese obia behu because ye hu Japa credibility the wa esibitie se na oye nipa papa na so onye nipa papa impo na danse a obedi a wanfa bi anya evidence ni nyani nyina na behu nti eno nam so ema NDC amanyoko ne lawyers eye worry say adenti na deputy attorney general person obisa sa question we na we so efa case no ebe na court no say ampa the deputy attorney general kan ne kwan so ano na court no agitu mu na Nsem-Pii NDC lawyers ni bisai Nsem-Pii na deputy attorney general ekafa assembly no yenkom also in a significant development in the ongoing ambulance procurement trial the deputy attorney general AG Alfred Tua Yeboa on Thursday tendered into evidence Richard Japa supposed dismissal letter from the Ghana Armed Forces. The judge eventually admitted the document into evidence despite the opposition by the lawyers of the third accused. The prosecution argued that Japa dismissal letter impertinent to establishing his character and the circumstances surrounding his involvement in the ambulance procurement process. The letter detailed reason for Japa termination, which included allegation of misconduct and breach of military protocols into papai ekanya editu dwa se krata a yede ba se yi papai edi afili military ni mu no eyade se na allegations bebre ewo ho nsem ne kra na enukura bi enim papai ntro a okotwa same thing si ehu obetimi aboa emiyehu se papai oye no kwafo anase ono enye no kwafo. In presenting the evidence, the deputy AG emphasized the relevance of Japa dismissal to the case, asserting that it highlights a pattern of behavior that could be critical in understanding the broader context of the allegation. The deputy AG argued that Japa dismissal for misconduct cast doubt on his reliability and trustworthiness, which are key elements in asserting the validity of his testimony and actions related to the ambulance procurement. Inti aha ena ebeye de se Japa oye trustworthy okopie mu military no na Ghana Armed Forces trust na na entro se ya na odi koko rem ena yetimi esake no ana eno ena deputy AG say what say yekom niemu the reason why nti yetimi esake no because nye easy say Ghana Armed Forces betimi asake wo ebobra onya hwe de we enso de onfa meto court no anim. Does that mean say o credibility sem ewo form o trustworthiness enso ejina ne naso anase enyina ne naso enye NDC amanyukuo no lawyers any Japa lawyers ye bia still deputy AG say he must know Japa denti a ono yetimi esake no edinifili military ni. Defense attorneys however raised objection to the introduction of the dismissal letter, arguing that it was prejudicial and unrelated to the core issue of the trial. They contended that Mr. Japa's past employment record should not influence the court assessment of the current charges and that the focus should remain on the evidence directly related to the ambulance case. The defense requests the court to disregard the letter as inadmissible evidence, citing concerns of bias. Enti Yera Richard Japa, a lawyer, editor, just say, my lord, obi adwuma okoye ene kwan e fa so yi na di an ambulance case yi a ye di enka efa ho bai enti se nke betimi a enka fa yemfa nto ba bi kura because ono na akwa akoye na adwuma na ye yi no adi. However, the judge admitted the letter into evidence after a brief break. She rejected the objections raised by the lawyer of Japa, stating that her decision is based on Section 60 on personal knowledge and 126 on official records. Japa told the court that the attachment title released from the service for unsatisfactory conduct was aligned to him. Enti judge after the Japa lawyer say say there be media to the reason why ntia ye Richard Japa edi no free military nim na no na Japa ebebie na no edi atudwa say my lord nsam a Ghana Armed Forces edi kato me so a eno enam ho a ye medidi free military nim nyina enya ade say no kra ba akokra etimi ewom na o say e unsatisfactory conduct. Enti ekanye say Japa de ono asem bi obi akato ne so bia enye no kra including say Ghana Armed Forces for kra etwa ntro e de ato ne so enti ye guso ayedi asem no ekọ nanim na sene awieye ene ye behu chale say ye kohwehwem na ye hu say the reason why ntia ye yi Richard Japa e de free military nim e ye say okakeka nsem gu amanfo bi hu fi ni or like ono otanhye amanfo image anase suban boni bi ena oda na di na yi ni film military nim dia ebetimi aba na aba be wie case ne so say de Japa kan nyina anya no kra because sa ena yera Richard Japa ni suban etie. Ena yera Richard Japa ono third accused on the case between Dr. Kissel Atoforsen versus the Republic. Na ade say yebeka ye call asetna on the last day no ade say na yera Richard Japa na ejina adakem ye toto na no na yebeka antoto na no anwie na state prosecutor Jamami Yvonne Atakra Obobisa eguso ono toto yera Richard Japa ano na wohwe ba bia case no ekọ na ade say NDC amanyekuo no afi de won epese won egi asem no efiri yewura Dr. Kessel Atoforsen so no mubu asem ni nyina edi egu yewura set tepeso enti ena Great Japa eba be pie mu e wo court no toto aye toto na no nyina opese o kire se Dr. Kessel Atoforsen de onye ahwini mum yewura set tepe ena aye bibi na jema ni Yvonne Atakra Obobisa nso ema ni hunu se why wadwene se obeyi agu se tekpa nkwa so a enya ade se enu betimi ayeye because per document ewa ha ekere se Dr. Kessel Atoforsen and make you authorization name enya yera se tekpa na eye na ade ensem na ye Richard Japa editu dwa na questions be na state prosecutor so ebisa no yenko ne nsem auditu edwa ene kwan state prosecutor. And so far so or say the third accused person in the ongoing ambulance procurement trial has testified that the letter from the first accused, Dr. Kessel Atoforsen, regarding the establishment of letters of credit was addressed to the Bank of Ghana and not to the Controller and Accountant General Department. Mr. Richard Japa highlighted that the letter authorizing the establishment of letters of credit for the procurement of ambulance was addressed to the Bank of Ghana and was on the then Finance Minister Sek Tepa's behalf. Inti and yera Richard Japa yera Dr. Kessel Atoforsen ato amanihunu because that letter no aye de kokoma Bank of Ghana no ono eka se yewura se tepe emom ne ma authorization no enya no kre ɛyɛ adeɛ sɛ yɛwura Dr. Kesel Atoforsen ɛna ɛma authorization ɛno nso ɛyɛ adeɛ sɛ state prosecutor no nso ɛbɛprovi ɛde akyɛ no per document a aba abɛtɔ court no anim. The detail he urged is crucial in understanding the context and appropriation of the authorization processes. Jakpa's assertion came as a defense against the allegation that Dr. Kesel Atoforsen acted improperly in the ambulance procurement processes. The third accused emphasized that the procedure followed by Dr. Forsen was consistent with standard governmental practices, and the letter directed to the Bank of Ghana aligns with the usual protocols for such financial transactions. This, Jakpa noted, should mitigate claims of wrongdoing attributed to Dr. Atoforsen. The controversy surrounding the procurement of the ambulance has seen Dr. Atoforsen accused of financial malfeasance, with prosecutors arguing that he bypassed established procedures. However, Jakpa countered this by stating that addressing the letter to the Bank of Ghana was not only appropriate but also necessary for the timely and efficient execution of the procurement. He argued that the Bank of Ghana is the right entity for the handling such transaction as it oversees the country's monetary policy and financial operation. In court, Jakpa details how the Bank of Ghana, rather than the Comptroller and Accountant General Department, is typically responsible for issuing letter of credit due to its role in managing the nation's foreign exchange and international financial transaction. He pointed out that this distinction is critical in ensuring that financial processes adhere to the proper channels, thus reinforcing that Dr. Atoforsen's actions were in line with the standard practices. However, the prosecution argues that the seal on the document indicates the authority of the former deputy minister, not the minister. Nti wei ɛkyerɛ sɛ ɛkwan a yɛwura Richard Jakpa ɛpɛ sɛ ɔfa so no yi Dr. Kesel Atoforsen efiri asɛm nim na afei ɛyɛ sɛ wɔn nyinaa epia asɛm no ɛde agu yɛwura sɛ takpɛ so no ɛha ɛna ɛbɛkɔ akɔfa confusion ni nyinaa aba. So now sɛ Dr. Kesel Atoforsen anya mfomsuo bia ɛwɔ ambulance no a yɛkɔtɔ ɛde ɛba anim a now hwan ɛna ɛyɛ mfomsuo, then it is sɛ takpɛ ɛna ɛyɛ mfomsuo ni nyinaa na aha ɛna sɛ takpɛ nso ɛbɛ pushi no na ɔno nso aba abɛpie mu wɔ court na ɔno nso akyerɛkyerɛ na afa mu deɛ a ɛwɔ na afei yɛhu baabi a mfomsuo no efiri ba nti cross examination no egu so a ɛkɔ so. State no egu so a wɔn ɛtoto third accused yɛwura Richard Jakpa ano a cross examination no egu so a ɛkɔ so ne ɛbɛkae a Richard Jakpa ɛkɔ court in the previous days no ɛba bepie mu sɛ Richard Jakpa na ɔno ɛyɛ military officer bi a yɛ dismissal no a up to now nyinaa emu nkyerɛkyerɛ mu kura na yɛn hyɛ da ɛhu baabi a ɛkɔkɔ akɔsi ɛne yɛ dismissal ne deɛ bebree ɛna yɛtimi ɛde ɛmaa no na ɛho asɛm kɔpie mu wɔ court no ɛnɛ ɛna afei asɛm no asan adane aba bɛbu abɔ ɔno a Richard Jakpa afei ne lawyerfoɔ koraa try sɛ ɔmo bɛ defend no but enye ye ɛdeɛ nsɛm ɛna aba bɛpie mu ɛwɔ Jakpa dismissal yi a ɔkɔpie mu wɔ military yɛde ɛmaa ni ɔsi her ladyship Justice Afia Sewa Asaribotwe has dismissed the objection by the lawyers for the third accused, Richard Jakpa, against the tendering of the dismissal letter of the accused from the military. The learned Tade Osori began his attack against the tendering of the said letter showing the dismissal of Mr. Jakpa on the ground of a failure by the cross-examining lawyer to allow the accused and witness in the box to identify the document which contained letters surrounding his dismissal before speaking to it. The learned Story, however, agreed that the witness could identify only the 2007 letter to which he was copied and not a letter from the Ministry of Defense addressed to the Attorney General Department dated June 2024. He went on with his onslaught by arguing that no background existed for the tendering of the document. He quoted Section 60 as a bar to the tendering of the document. Dr. Bamba tied his apron string to that of Mr. Sorry and threw his weight behind the argument canvassed by the learned Sorry. The learned Deputy AG, Honorable Alfred Twayebua, who held the cross-examination further for this part of prosecution in today's proceeding, reacted to the argument canvassed for the objection by the saying that the document, which were the dismissal letter of Mr. Jakpa from the military, dated 2007 and covering letter from the Attorney General Department and the Defense Ministries were relevant. Nti saa krataa no a ɛba bɛpie mu ɛwɔ court sɛ na yɛwura Richard Jakpa ɛyɛ military officer a yɛyii n'adi ɛde efiri mu no na nsɛm bi wɔm to it a nyɛ ne nyinaa koraa na yɛtumi ɛgo deep na nipa a ogyina Godfrey Adame anam ni atoto yɛwura Richard Jakpa ano ɛyɛ Deputy Attorney General yɛwura yɛwura Alfred Twayebua ɛna gyina mu a ɔtoto n'ano na Richard Jakpa alɔyafoɔ ɛde tu da sɛ saa nsɛm no ɛne letters ahodoɔ bebrebe a yɛyii n'adi no nyinaa ɛnyɛ adeɛ sɛ ne nyinaa ɔmo kae na mmom 2007 deɛ na ɔmo kae nti nka court no koraa ma ɔnyi ntoma saa asɛm wɔ ekura yɛ ntoa so nka ho asɛm ɛwɔ court dɛm ha because ɛno koraa ɛnka ho na ɛno ɛna Alfred Twayebua sɛ hwɛ ɛnaa no a Richard Jakpa ɛba bɛpie mu wɔ court ano ɛnyɛ mu nsɛm nyinaa na ɔde tu dwa wɔ ɛnɛ yɛba bɛkɔ deep ɛma obi ahu the main reason why nti a yɛyi Richard Jakpa yɛ dismissing ne film military no because o track record nso etimi ɛkyerɛ enipa a wutimi ɛyɛ. He argued that the document relate to his dismissal and said that the same went to his character. Mr. Sorry registered a repost to the argument about the character of the witness and said same was in breach of the Evidence Act 1975 NRCD 323. Her ladyship hung her decision on Section 60 and 120 of the Evidence Act 1975 NRCD 2323 with the overriding focus in relevance. Her ladyship said the witness had already acknowledged the document being tendered and has already said he can speak to it. On official document and the law of evidence on same, her ladyship said the covering letters are official documents and will be admitted to prove credibility or otherwise. Enti NDC amanyoko no Richard Jakpa lawyers na one etre say enka ehu hia saa no na judge a ote adwam say no ehu hia pa because se wohwe enipa background ene nneoma bi a oye no ninchi a eno na usually na ya na determine who the person is ebi kura na nipa na nipa boni ni through his bad records ebepie mu ewo court ade nti esake no one am ya nkomu details na Alfred Twayebua enso say one nso anya hint bi a ekire say de yewra Richard Jakpa eye yinti a yeji na di free military ni no na enye ade papa enti opese ode ka na evidence woni bisa no ho nsem ni ehu nipa kro a yewra Richard Jakpa eye nti a ono nani abrese obe defend Dr. Keseo Atoforsen a enye asemkoto cross examination no eguso e koso de better for bia je de be mamu